Number 293, Robert Eli Stanley versus Georgia. No, he might sum this up by saying that's a hell of a way to run a railroad.
May it please the court, I would like to request the marshal to notify me when 25 minutes is up. I'd like to save 5 minutes for rebuttal, if I may.
You'll find a white light come up in front of you. That will be the 5-minute warning.
Thank you.
Mr. Asanoff, you may proceed with your argument.
Thank you. Mr. Chief Justice and members of the court, this case involves the constitutionality of the Georgia obscenity statute. The questions raised by this appeal, insofar as the constitutionality of the statute are concerned, are twofold. First, we raise the question that the statute violates the First Amendment because it punishes the mere possession of obscene material without requiring any further overt act on the part of the possessor or intent to do anything with it.
What kind of possession was this?
This was a possession, if you honor please, where Robert Eli Stanley had possession of 3 reels of motion picture film in a desk drawer of his upstairs bedroom of his home. There was no allegation in the indictment of any showing or attempt to exhibit or show these films or pander them or show them to minors. The only question involved, insofar as the indictment was concerned, was that he possessed them knowing them to have been obscene, or that he should reasonably have known them to have been obscene. The second question of our constitutional attack on this statute is the use of the language in the statute and in the indictment to the effect that he reasonably should have known of the obscene nature of the film removes the element of scienter from the definition of the offense, and thus permits the state to secure a conviction for possessing these films on a showing less than actual knowledge on his part that they were obscene.
Are they conceitedly obscene?
We do not concede them to be obscene, and we took that position with the trial court that under the First Amendment, insofar as possession itself is concerned, that there is no such thing as obscenity. The reason we took that position and now take this position is this: that it would be a violation of the freedom of press clause of the First Amendment to restrict a person or to prohibit a person from possessing anything they want insofar as its claim of obscenity is concerned. We take the position that where a person merely possesses an article alleged to be obscene and does not attempt to distribute it or show it to any other persons, as was the case in this case and as was the indictment in this case, and as was the holding by the Supreme Court that the mere possession is an offense under the definition of Georgia law, that any evidence in the case on the part of the state or any contention on the part of the state to the effect that the evidence might have circumstantially shown that he was about to have a party and about to show these films to other persons would be completely irrelevant for this court to consider. Has no relevancy here because of the fact that he was only charged with the mere possession. Now, to my knowledge, this exact question has never been passed upon by this court. The question of whether or not a person can be prohibited by the states from merely possessing obscene material or obscene writings or pictures. Clearly, it would seem to me that the mere possession, that anyone would have the right to, say, draw a picture which might obviously be obscene to some other person and put it in his pocket or put it in his desk drawer. Or if he wanted to take a picture of himself or a picture of himself and his wife in a sexual act, that this would be a matter that he could determine as long as he did not attempt to pander this material, attempt to sell it, distribute it, or distribute it to minors.
I suppose when these films were in a desk drawer.
These films were in a desk drawer. This, of course, is the...
And of course, you couldn't just, looking at the film, you couldn't tell what it was.
Could not.
Now, what did the officers do?
The officers, and this is, I might as well mention this at the outset right here. The second part of our contention is the officers were armed. They were federal and state officers were armed with a federal search warrant issued by a United States Commissioner on a claim that the defendant was violating the Wagering Tax Act.
What?
The Wagering Tax Act.
Oh, yeah.
Since then, of course, this court has held that the provisions of that law are constitutionally impermissible.
What I'm trying to get to is, did the officers use the projector to see the film?
Yes, yes. This,
then and there?
yes, sir. Then and there. They went in armed with the search warrant issued by a United States Commissioner, which did not call for the seizure of any obscene films, but called for the seizure of gambling paraphernalia. No gambling paraphernalia was seized except some negligible things that I think the state concedes were not sufficient. But during their search, they searched through this drawer and found 3 cans of film, 8mm film, which they testified they could not discern or know from their own knowledge that it was or what it was. So they found in the closet a projector, and they found a screen. And they showed these films and looked at them, and after...
They set up the screen and set up...
Then they set up the screen and they showed them.
Is there any conceivable circumstance in which, if you saw a film, that could it possibly be connected with gambling paraphernalia?
I would think not. I would think not. I wouldn't know that there was any connection between them. But what happened after they showed these films, and not having a warrant to seize the films, the evidence shows in the case and in the record that the officer, the state officer, called the Solicitor General, who is the prosecuting officer for that circuit, and told him they didn't find gambling paraphernalia, but that they did find some films. And it's in the record that the Solicitor General then stated to him, after you view the films, if in your opinion they are obscene, seize the films and book a case and I'll set a bond.
Well, tell me, suppose instead of these films, they'd found counterfeit bills. Could this fellow have been prosecuted for possession of counterfeit bills?
I think so.
Yeah. How do you distinguish that?
I distinguish that, and I concede that where evidence is seized or where contraband is seized, where it's not such as would be subject to a claim of the First Amendment, freedom of press or freedom of speech, that the states do have the right to prohibit the possession.
I take it Harris would require that as counterfeit money, wouldn't he?
Yes, I think any case, and we can see that in our brief and make that distinction, that in this particular case, these were films alleged to be obscene from the very start. They weren't seized as gambling paraphernalia, but they were seized under a warrant issued by a United States Commissioner under the Wagering Tax Act, under a contention that the defendant had not registered as a gambler.
Was this man a merchant or distributor of any kind?
No, was not. There was no claim of any distributorship. He was an individual in his own home. The state, of course, alleged and contended that he had a record for gambling in the past and that federal agents and state agents were going in for that purpose, that they had probable cause, one of the contentions in the affidavit being that he had not registered as a gambler and paid his tax, which, of course, since then in Grosso and Machete, this case has...
In the prosecution and the actual trial for possession of these films, was there any effort to reduce proof that the possession of the films was for the purpose of sale?
No, sir.
It was just naked possession of the film.
This is the...
No, there was one other point. There were biscuits in the kitchen.
This was brought up in the brief to this court, that there were biscuits being ready to put in the stove, that there were well-dressed people who came to the house, that this man was a bachelor and his girlfriend had come there, and that the officers had turned them away. They said that the table was set for 8 people, looked like they were fixing to have supper, getting ready to have supper, and for this reason they said that apparently he was going to have a party. This is now the contention raised by the state. But I want to call the court's attention to this.
Where was that?
Sir?
Where was that in Georgia?
In Atlanta.
Was there any claim that this party was going to include the showing of these films?
That's what they claim. They claim circumstantially. There's no evidence of that at all. The defendant denied knowing anything about the films.
As I understood you to say, neither screen nor projector were set up.
That's right.
And the films were in cans in the desk drawer.
Upstairs in the bedroom of the defendant in a desk drawer.
But you say the claim, was there any effort at the trial to show that he was going to have a party including showing these films?
No, sir. None whatsoever. No testimony of that at all.
What do you do with films normally?
Well, I would imagine that you would show them.
Souvenir or show?
Well, I think that an individual could do as he pleases with them. But the point is in this case, and this is the paramount thing in here, that the state did not contend by its indictment that he had any intent to show them. And this was one of our grounds of demurrer in the trial court in the state court.
Show them to somebody else.
Whether there was any intent to do anything with them.
Or even show them to himself?
Well,
but himself, there was nothing, as I understand you, there's nothing indicate except that he had them in the drawer and he had in the closet, he had a projector and
That's right.
and a screen.
Could have shown them for his own use.
Or maybe he wasn't going to show them at all.
Maybe he wasn't going to. He contended by his...
Keep some of the keepsake.
But he could. In his statement, he said that I have never seen these films before, that a man brought them to my house on Labor Day, which was about 4 or 5 days before this. But the point was that the state at no time in its indictment charged this. We demurred on the ground the vagueness of the Georgia statute. The Georgia statute did not specifically make the mere possession an offense. And we asked for interpretation by the state court and got it. The Supreme Court construed the language to be sufficient to make the mere possession an offense. And that's why we're in this court. Because of the fact that we are reinforced by the state court decision holding that the mere possession is an offense. And we say that gives it an unconstitutional interpretation.
The nub of this case appears on page 69 of the appendix, doesn't it? Right at the top of the page, that one sentence.
I believe so, Your Honor.
It is not essential to an indictment charging one with possession of obscene matter that it be alleged that such possession was with intent to sell, expose, or circulate the same.
That's correct.
And that's a clear holding by the highest court of your state, that mere possession, or as my brother Brennan says, naked possession, is sufficient to constitute a criminal offense.
That's correct. That is the holding of the Supreme Court, so the question is squarely before this court as to whether or not, under that interpretation given to it by the Supreme Court of Georgia, whether or not that can be squared with the First Amendment, whether mere possession of material alleged to be obscene, pictures or writings, can be constitutionally made a criminal offense.
Get it down a little closer. It is that the naked possession, pictures of naked persons, cannot be kept in a person's house, for that is committing a crime.
Under Georgia law, under the interpretation given by the Supreme Court of Georgia, that is correct.
What did this fellow get? A year?
Yes, sir. He received a year's punishment in prison. That was fixed by the jury. And it was under the charge of the court. Of course, under Georgia law, peculiarly, the jury fixes the punishment. And under the charge of the court charged the mere possession as being that's all they had to consider, together with either that he had knowledge that they were obscene or that he should reasonably have known of its obscene nature. Now, this gets to the scienter question. Whether or not a state can withdraw the element of scienter by permitting a conviction to rest upon less evidence than actual knowledge that it is obscene.
Has your client been out on bail?
Yes, sir. He's been out on bail. The second question involved in this case, as I've stated, is that this court has held in Grosso and Machete, since this case was tried, that the Wagering Tax Act is constitutionally unenforceable. Now, this holding by the court, we say, renders the search warrant that was issued in this case invalid. We filed a motion to suppress in the trial court. In our motion to suppress...
When was the search warrant issued?
The search warrant was issued before Grosso and Machete decision. It was issued 1967, but it was some months before Grosso and Machete. But we filed a motion to suppress the evidence. And in our motion, the allegation was made that the films were seized without a valid search warrant, particularly describing the articles to be seized. That language, we say, is sufficient to now reach back as of that time and say that that was a sufficient attack upon the warrant itself.
Do you argue at all that even if the warrant was valid and even if Marchetti and Grosso aren't retroactive, that nevertheless the search was invalid because the warrant described gambling paraphernalia, and they nevertheless seized a film which it isn't like running across contraband that you can that's lying out in plain sight. You have to actually look into the film to find out what's in it.
Not only look into
make that argument?
Yes, sir. Not only look at the film, but there had been this requires, on a question of obscenity, it would require at least the finding of a magistrate to determine that these films were obscene. In this particular case, the evidence is clear that this officer called the Solicitor General and asked the Solicitor General what to do, and he told him, if in your opinion they are obscene, seize the films and make a case and I'll set the bond. Now, we say that this would require, before a film or a picture or photograph or anything else can be considered to be obscene, there must be some judicial finding, some notice, some knowledge that these films have been declared to be obscene, at least that much. And we say that for that reason, that even though officers would be authorized under search warrants to seize contraband not named in the article, that they would not be authorized to seize films alleged to be obscene, that the Solicitor General himself had no judicial powers under the law of Georgia, had no right to himself have seized the films, but in this case he delegated some sort of judicial power to the officer making the finding and told him, if in your opinion they're obscene, to make a case.
I take it you're relying on Marcus. You're relying on Marcus?
Yes, Marcus case.
Of course, Marcus involved, as I recall it, didn't it? A warehouse full of books, of which there were 6 or 7 that the police had purchased. And there, on the basis of police examination of the books, they issued the warrant.
That was under the Missouri statute.
And we said that they had to have a determination in advance, but it's a little different. Here you have just a single item. Just how would you get the film to have a determination of obscenity before a search warrant issue?
If the Solicitor General had instructed the officer, submit your facts to a magistrate, and if he determined,
so he'd have to take the films.
No, he could by affidavit submit to a magistrate who was authorized to issue a warrant. He could submit what these films revealed to him.
According to another argument, he wasn't even entitled to look at them.
That's right.
That's right. He was not even entitled to look at them, which, of course, is again the question. But we say under either one of those theories, the seizure of the films was illegal.
Well, it wouldn't be obscene unless it lacked some socially redeeming value, as I understand it.
Well,
you couldn't tell that unless you saw it.
Of course, Your Honor, that's true. But I think that's something that has been the subject of discussion for many, many years as to whether or not an item does have redeeming social value or whether or not it could be classified as obscene. Whether or not
these movies shown at the trial?
Yes, sir. The movies were shown at the trial.
The jury trial?
Yes, sir.
Are they here?
Yes, sir. I think this court has them. And I would say this, that of course, I think, and I would concede to this court, that the pictures, the films, insofar as films are concerned, I think are disgusting, but I don't know that disgusting makes them obscene. I don't know that they would appeal. They wouldn't appeal to my prurient interests. I don't know whose prurient interests they would appeal to because I think that they're sickening. But I don't think that they'd be any more sickening than it would be to show a man being tortured to death and having his guts tore out of him. But that wouldn't be obscene. It's really hard to say what obscenity is, but getting right to the point in this case, We say that if they are the vilest, the foulest, the filthiest pictures that could ever be seen, that a person has the right to possess them as long as he is not, and this is what this court held last year in Redrup and the other cases along with Redrup, that as long as there is no pandering, as long as there is no exhibition to minors, and as long as there is no intrusion upon the privacy of other persons who are unwilling to see them, then of course we have nothing. And this is all we have in this case. Unless we want to accept the state's theory that because there was some biscuits being prepared to put in the stove, because of the fact that there was a table was set for 8 where they were going to have dinner, and against the statement of the defendant on the trial of the case, nothing to refute that a man had brought these films to him several days before and told him, said, I have some films I'd like you to see. Now, we say this, if the court please, that wherever we find that a question of obscenity is concerned, or whether or not we know that something is obscene, if A tells B, I have some pictures here I want to give you, and these pictures are obscene, does that say that B cannot determine or ascertain for himself whether they are obscene to him? Or does that mean that he would have the right to himself inspect those films and say, I have a right under the First Amendment to determine...
You don't have that case here. Why argue that case?
Well, that is what it would actually...
All you have here, as I understand it, assuming the obscenity of these films, a question whether the possession, and nothing more, not for sale or otherwise, but just possession of itself constitutionally can be made a crime
That's
like
correct.
the First Amendment. Is that what it is?
That's right. And that's why I say, if you want to please, that because of that, a man has the right to determine for himself if it offends him, if to him it's obscene, because it would violate the First Amendment to say that if a man handed me some film...
Is there anything in this record to show that he had any knowledge of what these films...
None whatsoever, except the fact they said an expert testified that the films had been scratched. One of them was wound backwards to show that someone had seen them at some time in the past, but nothing to show that he had seen them or he had ever viewed them. And there's nothing to refute or rebut his statement that he had never seen them before.
Well, they're in his trunk upstairs or bureau drawer?
He was in the desk drawer of his bedroom upstairs. And there was no setup, nothing set up, no screen set up to show these or view these films.
The difference between this and the Wilkes case, which was tried a long time ago, is that there they found the paper in the bottom of his trunk. Here they found it in the desk drawer.
Well...
And they turned them loose.
I think that would be analogous. So I would like to reserve what time I have. I know the white light hasn't come on. I would like to reserve, if I may, the time for rebuttal.
You may. Mr. Sparks?
Please, the court, I am the trial counsel who prosecuted this case in the court below, Superior Court of Fulton County, so the court has the original trial counsel. Mr. Asanoff was a defense counsel. Now, I want to point out several things to the court which I think Mr. Asanoff neglected to point out because he was so wrapped up in his own argument. One is this, on the question of whether or not this Georgia statute contains the element of scienter, I want to point out to the court that the Supreme Court of Georgia ruled on that in this very case. The court said, I'm just reading in part, just a line, it being contended that the requirement of reasonable knowledge would withdraw the element of scienter from the definition of the offense and would render a person guilty without actual knowledge of the obscene nature of the matter. This contention is without merit. Now, Your Honor, as we have pointed out in our brief, this court has consistently held that where a state statute is interpreted by the highest court of its state, that this court is bound by the construction placed on it by that court. That happened in the Michigan case, another obscenity case, which the court, of course, is familiar with, and also in the last Ginsburg case. Now, in the last Ginsburg case, the New York statute, which defined knowledge is this, the word knowingly possess obscene matter. The New York statute defined knowingly as having general knowledge of or reason to know, the exact same words that are in the Georgia statute, or reasonably should know, or a belief or ground for belief which warrants further inspection or inquiry. In other words, in the Ginsburg case, and that's a Ginsberg case, being two Ginsburg cases in the obscenity field, this court accepted the construction placed on the scienter feature of the New York statute and said, as we are bound to do. Now, the Georgia Supreme Court said, in response to Mr. Asanoff's contention, that the language of the Georgia statute, if such person has knowledge or reasonably should know of the obscene nature of the matter, does not remove scienter from the offense, but is merely a statutory expression of a rule of evidence which has been extant in Georgia courts for many years. That is, the only way you can prove intent or knowledge of a person as to anything, as to whether goods are stolen, or of any element involving intent or knowledge, unless he confesses, is by the circumstances, as to whether a reasonable man in the same position would know or would have knowledge of the obscene nature. So I submit very respectfully that by a long series of this court's own decisions, that you cannot go beyond or reverse the judgment of the Georgia Supreme Court on this question of scienter, because that is the state court interpreting its own statute. And I have cited a number of cases where this court has said that we are bound by such expression. This court also said it in the Michigan case. You said it in the Kingsley International Picture Corporation case. In about 8 cases, Aero Transit, all of which are listed in our brief. So that moves us on to the second facet of the attack on the constitutionality of the statute. I submit most earnestly to the court that scienter is an element of this offense as interpreted by the Georgia court, by the Georgia Supreme Court, and that this court cannot, unless you reverse your prior rulings, which are set out in our brief and which I have cited to you, unless you reverse that long line of cases, I don't believe the court could, in keeping with its precedent, just say, we think the Georgia court was wrong when they said that this statute does not contain the element of scienter. It's almost exactly.
What was the state's evidence on scienter?
The state's evidence?
To prove scienter.
It was circumstantial, Your Honor, but we think that it was sufficient. These officers went in with a federal search warrant to seize wagering paraphernalia. This man was alleged to have been a notorious bookmaker with a prior record of arrest and a conviction. Upstairs,
Of course, that wouldn't have any connection.
That wouldn't have any connection with this case, but I was pointing out the probable cause that we had. There were 28 pages of probable cause.
How you brought evidence, and what evidence there was upon which the jury could find that he knew the contents of these motion pictures.
One of the cans bears the label Young Blood on it, which is certainly a suggestive title. It's a homemade label. I gather from what the court has said that the court hasn't viewed these films. They are here, and I've asked the court on about.
I'd still like to know, if you don't mind,
all right,
what the evidence was that brought home to him knowledge of the contents of those movies.
Well, the evidence showed, Your Honor, that in the upstairs living room, there was a projector set up and a bunch of innocuous films, slides, travel logs, things like that. These films were not found with the other films, the innocuous or innocent type films, but they were found in a desk drawer underneath some papers in his private bedroom. An officer, the officers ran them, threw them against the wall, and then went downstairs and told him, says, "We are arresting you for the obscene films which were found upstairs."
Well, why did they show the films? They were looking for what? The search warrant was limited to what?
It was limited.
And with that posture, why did they want to look at the film?
Mr. Justice Marshall, I think that they wanted to look at the films for the reason that the films might have been records. They were authorized to look for bookmaking records. And it's not inconceivable that...
They would have them in a tin can marked Youngblood?
Yeah. You could. Just like the old purloined letter scheme of Edgar Allan Poe, the story about putting something in the most conspicuous place.
I'm sure the policeman read Edgar Allan Poe.
And as soon as you saw the first film, the first frame, you thought you were still looking for records?
No, sir, but there were 3 cans.
They ran up through all 3, I think.
They didn't show all 3 of them, Your Honor. The record shows they only showed a few feet of the second and third one. In fact, one of the films had been rewound backward, which shows recent viewing, and the pictures were thrown upside down.
Now, you were going to tell us that he went downstairs, and I gather you were going to tell us he met the defendant, the officer did?
He went downstairs and met the defendant and told the defendant that, "I'm arresting you for those obscene films upstairs." The defendant said nothing. Now, of course, I don't claim that you can't use his right to remain silent against him. That's a constitutional right. But it would still seem more logical to say what films if he didn't know that he had any obscene films.
All right.
But of course...
So far he said nothing.
Yes, sir, he said
now,
nothing.
What else have you got? The officer said to him, "I'm going to arrest you for those obscene films." The defendant said nothing.
He said,
now,
let me call Mr. Asinoff. And he did call Mr. Asinoff.
Now, the fact he called his lawyer, does that indicate he knew what the films were?
No, sir, but there were his own statement. He made a statement on the trial. Georgia has the unsworn statement law, where a defendant can either be sworn or make an unsworn statement. This is what he said, and while it is not any admission, it's still significant, I think. It's very brief. He said, "I'm a bachelor, I live by myself, and I have a girlfriend. We planned a party for Labor Day. I invited several couples out. Later on in the evening, a friend of mine came by and said, 'I brought you something I want you to see.' He handed it to me. It was 3 rolls of film. I took the film upstairs and put it in the desk drawer, closed the desk drawer, and came back downstairs." Then he goes on to say he never looked at it. However, there were two people were in the backyard when the officers made the execution of the search warrant. 2 men. 3 women came over later that evening, well-dressed women. There was Justice Marshall's 3 dozen biscuits sitting on the stove. All the indications were that there was going to be a party, and in fact he told the jury that he was going to have a party. And in the connection, the context of his statement telling about the party first and a friend bringing the films by and saying, "I want you to see them," I think it's a reasonable deduction that the jury could have drawn that the films were to be shown at the party.
Well, is there anything in what you have told us to support an inference that he had looked at the films and knew what they were?
Only one of the federal agents was a former professional photographer, Your Honor, and he testified that the films were badly scratched, that they were dirty, that one of the films had been wound backwards, which caused the figures to project upside down on the wall when they showed it, and he said that they had obviously been used before, been shown before many times. It was a
Many times, did you say?
I'm not certain whether he used the word many or not. I know that he said that they had obviously been shown before, that they'd seen, I believe he said he'd seen extensive use. I could find that for you.
We'll adjourn now. 3, Robert Eli Stanley, appellant versus Georgia. Mr. Sparks, you may continue with your argument.
Mr. Chief Justice and Honorable Justices, at the recess yesterday afternoon, I was just completing my response to questions by Justice Brennan, as to the evidence of scienter, and I had practically completed my summary of the circumstances which we feel justified a jury to find that this defendant knew of the obscene nature of the matter. I just want to elaborate in one respect.
You really aren't arguing that, are you? That he knew it was obscene? You're just arguing that he knew the contents of the film.
That's right, the contents of the film. That he knew the contents of the film, of the obscene nature of the film. That is the way the Georgia statute reads, I believe. I just want to point out two things in relation to his statement, and I'll move on to something else. In his unsworn statement, he attempted to explain his possession of the films in a manner consistent with lack of knowledge of the contents, and I submit that it was unreasonable explanation, somewhat unreasonable in two respects. First, he said that a friend brought the films by and left them with him, saying that he wanted the appellant to view the films. I submit that it's somewhat unreasonable that films would have exchanged hands without some explanation on the part of the unknown friend or some query on the part of the appellant as to what kind of films are they. Particularly the small 8mm films in the can with a homemade label. I feel quite sure that if anyone came to me and said, "I've got some films I want you to see," I'd say, "Well, what are they? Films of your fishing trip or your family or..."
Well, what if you asked him that
Then I think you
that's why he said, "Oh, that's interesting." Would you have any clue that they were seeing films?
I think that would warrant further inquiry, Justice White.
Maybe. What evidence is that there was any further inquiry or any further investigation of what was going on?
There is no evidence because, of course, this was an unsworn statement, and the state was not allowed to cross-examine him or go into it without his consent unless he voluntarily submitted himself to cross-examination.
Well, the state had the burden, didn't it?
Sir?
The state had the burden of proof, didn't it?
Yes, sir, the state has the burden of proof, Your Honor, but I think this is both federal and state law, as I recall from my days as an assistant U.S. attorney, that where the defense goes ahead with an affirmative defense, then not the burden of proof, but the burden of making a reasonable explanation shifts to the defendant. And that leads me to my next point, and that is that he did not identify his friend.
Stanley,
he neither produced him nor identified him by name.
In that statement, he also said, "I never saw the film before today. I never had shown them to anyone, so help me."
Yes, sir, that is true. And I want to point out in that connection before I pass from this subject, the case of Smith versus California, which this court decided, in which a defendant was convicted for the offense of bare possession of obscene matters under California ordinance, which had no element of scienter as interpreted by the California Supreme Court. And the court said, in an opinion by Mr. Justice Brennan, we might observe that it has been some time since the law viewed itself as impotent to explore the actual state of a man's mind. Eyewitness testimony of a bookseller's perusal of a book hardly need be a necessary element in proving his awareness of its contents. The circumstances may warrant the inference that he was aware of what a book contained despite his denial. And I submit that those quoted words are pretty analogous to the facts in this case. We are relying on the circumstances. We have no direct evidence that he saw, that he even knew what the films were, but we submit that all of the circumstances, the impending party, the films concealed, the title Young Blood, his rather inadequate explanation.
I'm really interested. How does that title suggest anything? I don't get this. Young Blood? What's that suggest? Or is it my age? I don't know.
Well, I think it suggests sex, Your Honor. We normally associate sex with young blood, with young people.
I guess it is my age.
I want to pass on to another point. I gathered yesterday from the questions asked my worthy adversary, Mr. Asanoff, that this court has not yet viewed the contents of the film, which were transmitted to this court by the direction of the Georgia Supreme Court. I wish to most respectfully and humbly urge this court to view the films before ruling on the case.
Do you think we have to view the film if there are? Do you think we have to view the film if there are constitutional bases that don't relate to the subject matter of the film for disposing of this case, such as the question of mere possession or the search and seizure question? How would you want us to view the film?
That was going to be my very next statement as to the legal reason why I feel that the film should be viewed.
Even if we think that you can dispose of this case and must dispose of the case on the possession ground or the search and seizure, Fourth Amendment ground.
Yes, sir, I do for this reason.
Tell me why.
This court, or the majority of this court, has consistently held in obscenity cases from Roth on through Jacobellis, Michigan, Ginsburg, Memoirs, even Redrup, I believe, and the last Ginsburg case in 1968, that obscenity is not protected by the First Amendment to the Constitution. And if the court views these films and finds that they are not only, that they are not borderline obscenity, but are hardcore pornography.
If this is obscene, we should not reach the Fourth Amendment question?
Should not reach the First Amendment question.
The Fourth Amendment question, search and seizure.
Oh, no, sir, but I'm not saying that. I think, well, as a matter of fact, I am not absolutely certain, Justice Stewart, that the search and seizure question is actually before this court, because it is
this is Stewart.
Sir, oh, Mr. Fortas, excuse me, I'm sorry. Search and seizure is not an appealable question. The court noted probable jurisdiction without restricting the question to the only appealable question, which is the constitutionality of the Georgia search and seizure, the constitutionality of the Georgia Obscenity Act. And the same thing happened in the Michigan case, and the court dismissed, they said that the search and seizure question was properly briefed by both parties, but then declined to pass on it and said that probable jurisdiction had been erroneously noted as far as that's concerned. However, I do feel that the court would have to pass on the search and seizure question, but right now I'm addressing myself to the constitutionality of the Georgia statute.
I want to be clear on one matter with respect to your position.
Yes.
Now, here's some allegedly obscene films. I haven't seen them, but if I should decide that this case must be reversed on the possession point or on the search and seizure point, Fourth Amendment point, I would not consider it, as presently advised, I would not consider it necessary to endure a sight of motion picture films, whatever their content may be. And do you consider that, do you disagree with that present thought of mine?
I disagree with it, Your Honor, so far as the First Amendment.
I'm not talking about the First Amendment. I'm talking about the 2 points that I'm talking about, namely the possession and the manner of seizure, which are Fourth Amendment points.
Well, Your Honor, I feel that the possession is the First Amendment.
And maybe the possession is a First Amendment point in a sense, but not in the sense that you're talking about, I take it.
Well, the appellant is asking this court to declare a mere possession count, I say mere possession with scienter, count unconstitutional.
But if we should conclude that a statute making mere possession a criminal offense is unconstitutional under the First Amendment, regardless of the nature of the films, then it obviously wouldn't be necessary for us to see the films, would it?
Your Honor, I take the reverse position. I say that you should see the films, and if they are hardcore pornography and outside the protection of the First Amendment, as this court has held in Roth and a whole series of cases, then it would not be necessary for the court
but I say assuming that we felt, assuming that I should conclude that so far as I'm concerned, mere possession cannot be punished as a crime regardless of how obscene the film might be, then it would follow that there'd be no point in my seeing the film. Isn't that right? So that seems to me to follow as a matter of course. Now, I know your position.
Yes, sir.
Is that if the film is obscene,
right,
mere possession can be punished. But I say that if I disagreed with that, then obviously it would not be necessary for me to endure a sight of this film. I'm not characterizing it as obscene. I don't know whether it is or not, but it probably is not one of the greatest works of art that's ever been struck by the hand of man.
That's an understatement, Your Honor.
Your real point is, isn't it, that our approach to some of the legal questions might be conditioned with themselves.
Yes, sir, that's correct. That's what I mean. If
obviously that's quite irrelevant. It's not a debating point. I hope you're going to address yourself to the constitutionality of this statute. Mere possession without any purpose to exhibit, sell, or display.
Yes, sir, that was going to be my next point. To the best of my knowledge and research, and I believe my...
Let me ask you before you do that.
Yes, sir.
As I read the record, it seems to me that the only time it's established by evidence that the picture has been displayed in Atlanta was when it was displayed at the prosecuting attorney's office to a group of people. Is that right?
That is the only evidence that it has been displayed in Atlanta. I recall that Your Honor asked me... Yes, sir, you're right, sir. Thank you. They looked at it in the appellant's home. And yesterday, Justice Black, you asked me about what the expert photographer said. He said that the films are badly scratched, dirty. They are not in new condition at all. That was from where I had mistakenly said that they had seen extensive use. They are not in new condition at all. One reel rolled backward, never rewound after showing of the film. And he says, yes, sir, they obviously had been shown before.
But where in the record does it say they were shown in Georgia before? It doesn't say it at all. It says it was shown someplace before.
That's true, sir. We didn't have any eyewitness who watched this appellant show the film.
And the undisputed evidence was that the appellant had barely come into possession of these films that very day.
That was not evidence, Your Honor. That was in the form of an unsworn statement.
Well, you've been talking about it, though, as a basis for much of your argument.
Yes, sir. Under Georgia law, the jury can pay what attention to it wants to. It can either disregard it or leave part of it.
Are you suggesting that we should disregard that statement entirely?
I'm suggesting that the court should consider it and consider the deficiencies.
Well, if we do, then we know that he had barely come into possession of the film.
Well, I'm not saying that the court should believe it all in its entirety. Because the natural thing for him to have done was, if that were true, to have brought the person in court, or at least named him so that the prosecution could have brought him into court. I have only a couple of minutes left, and I haven't even addressed myself.
You really mean bring him in court, or you would have arrested him, wouldn't you? Because he would have admitted that he had possession of these films.
It's entirely possible, unless he had denied it. He might have said, no, sir, I don't even know Bob Stanley. Never saw him before. And certainly I didn't give him any films. Then we would have made a state's witness out of him to have proven the defendant made a false statement in his unsworn statement. On the question of which Justice Harlan asked me to address myself to, the constitutionality of a possession statute, I really see no reason why a possession statute making hardcore pornography obscene cannot be constitutionally enacted by a state. States have many possession statutes, and the court knows them as well as I do. Possession of stolen goods, possession of concealed weapons without having licenses for them, possession of narcotics, possession of dangerous drugs, possession of burglary tools. The federal government has many possession statutes alone. Possession of a stolen car transported in interstate commerce, possession of money taken in an FDIC bank robbery, many possession statutes, and even during Prohibition days, bare possession of intoxicating liquors of any type was an offense. And I see no reason why the possession of hardcore pornography should not be made an offense. And I know of no case which, I think this is a case of first impression before this court. I have not been able to find a case exactly in point. Now, in the Smith case, which this court admittedly reversed, but only because there was no scienter, it seemed to me that the opinion, which I've quoted from once before, indicates or implies that had the California ordinance had the element of scienter in it, that it would have been constitutional, because Mr. Justice Brennan said this: we need not, and most definitely do not, pass today on what sort of mental element is requisite to a constitutionally permissible prosecution of a bookseller, as quoting, for carrying an obscene book in stock.
For sale.
That is it.
For sale. For sale. What's bookseller mean?
Yes, sir, but Your Honor, the California ordinance did not have any element of carrying it in stock for sale. It just said possession. Absolute liability, absolute criminal liability.
But that case did involve a bookseller.
It did
involve a prosecution for having books for sale, didn't it?
And I cannot see, honestly, where the First Amendment grounds hit this particular case. This man is not a bookseller. he was suspected of being a bookmaker rather than a bookseller. He was not intending to sell these films so far as the available evidence indicates. The general public was not deprived of the right to look at the films. The Georgia Supreme Court, in distinguishing this case from the Marcus case, said as much in its opinion. It said that the Marcus case on the search warrant, Marcus versus search warrant, it said that that case involves freedom of the press and freedom of speech. This case does not. And I don't think this case involves, under the facts of this case, this is just an individual. He is not being deprived of his right, though the public, I should say, is not being deprived of the right to view his films. I see I have the red light. If I might just... I might just say this, if I might be allowed one more sentence. I feel that a possession statute is necessary for effective law enforcement from the very type of evidentiary problem which has been pointed out by questions from this court. If you catch a man with the pornographic material, how are you going to prove that he has read it or that he has looked at it or that he intends to sell it? You can stop pornography at its source. And I honestly submit that this is the hardest type of hardcore pornography that this court has ever had before it. Thank you very much.
Mr. Asinoff?
May it please the court, with respect to Smith versus California, that prosecution involved a bookseller under an ordinance providing or referring to booksellers. Consequently, the sale, we're dealing with a person there who is in the business of selling books.
Give me your view of how you would argue the possession point, accepting the fact that the court has said that obscenity is not protected by the First Amendment.
In the Roth case, where that principle was established, we find that the Roth case was a question of distribution. And in an instance where an individual who is possessing something that we'll admittedly say is pornographic, the Constitution does not protect him from the distribution. And this is followed in the Red Rock case.
But the case said the obscenity isn't within the First Amendment.
That's correct. But the case was dealing with a question of the distribution.
You mean obscenity in the course of distribution is not protected, and obscenity just in possession is protected?
That's correct. The case did not hold that bare possession or mere possession was not protected. The court said in Roth that obscenity was not protected, but they were...
Well, the material doesn't change any, so what is the critical fact? The material, whether it's distributed or not, is the same, and it either is or isn't protected by the First Amendment. So what is different between possession and distribution?
Because...
What should you really focus on?
Well, in the distribution, you're dealing with a question of furnishing it to others. And the mere possession in your own privacy of your own home, where no one else has seen it, and there's no evidence that anyone has, or no one else is intended to come into contact with it. I say that no case holds that it is not protected, that an individual cannot take a picture of his own obscenity and for posterity for himself if he so chooses. Because to do so, to prohibit a person from possessing it, would in itself violate First Amendment rights. Because...
What do you say to your adversary's argument that the state constitution say we'll nip this business in the bud by suppressing it at the stage of possession, given the hardcore pornography, whatever you want to call it? What do you say about that? That in itself would be a violation of the First Amendment. To say that a person could not write what he wants in his own diary, let's say, that he's going to keep for his own personal future in his own drawer, not to be shown to any other persons. We say that the First Amendment is an absolute amendment,
that gives the man the freedom of the press, and the freedom of the press carries with it the freedom of motion picture films.
Well, the court has held, at least the majority has held, that it is not an absolute right that Kennedy did. The majority.
But that was held in the Roth case, if you want, please. And the Roth case involved...
That premise.
That's right.
What your adversary is saying is that the state legitimately, again, on the premise that what is involved here is meets the right.
Then we come into the Red Rupp case. Well, then we come into the Red Rupp case, which was decided since Roth. And this court last year in Red Rupp and the other cases that went with it reversed on the theory and on the principle that there had been, that this was not a case involving one of the three elements, either distribution to minors, distribution to persons who are unwilling to see it, or pandering, as was held in Ginsburg. Now, if we accept Red Rupp as being the law, then of course we must take Red Rupp and Roth together, as they both hold, and say that obscenity, insofar as it's mere possession and bare possession, and I use that expression, the bare possession is concerned, would be protected by the First Amendment, because there you are not intruding upon the privacy or the rights of others to be free from this stuff. Now, in the finding, one thing I would like to answer my opponent with respect to, he says that the state court found that the state statute did not remove the element of scienter. Now, the rule, as I understand it, is that this court will accept an interpretation placed upon a state court as to a non-federal ground, but as to a federal constitutional ground, this court is not precluded by virtue of a holding of a state court on a constitutional issue from reversing that state court, because this is the final arbiter. This court is the one that must decide the federal ground. Now, secondly, in the brief of the appellee on page 45, he cites the case of Rainwater versus Florida, which was decided by this court during the last term. The Rainwater versus Florida case was one that originated in the state court. There was a federal search warrant issued under the Wagering Tax Act, certain items from the defendant's possession, and they prosecuted him in the state courts. This court remanded that under the theory of Grosso and Machete, remanded it back to the state court for further proceedings, not inconsistent with Grosso and Machete. This is identical to the case we have here. The state says in its brief that there, the prosecution in the state court was the end result of the issuance of the federal search warrant. That's what we have in this case. This prosecution for obscenity was the end result of the issuance of the federal search warrant, which actually, under the Rainwater versus Florida doctrine, was inadmissible as having been unconstitutionally obtained. Now,
to get back to this possession point, under the state law, if assuming that possession were a crime, mere possession was a crime and not boxed by the First Amendment, could the state get out a search warrant to search your own library on the basis of an affidavit that would say that you have in that library a copy of James Joyce's Ulysses, and a copy of this book and that book, and that there was, and therefore they get out a search warrant to examine your entire library?
I would not think so. I think that the Constitution, the Fourth Amendment, says that the warrant shall particularly describe the articles to be seized.
In other words, that they'd have to name the specific book.
That is my view of that amendment. Now, one point that was raised by my adversary, he says that the evidence in the case indicated that one reel of film had been wound backwards or was scratched, and that would indicate that someone had previously viewed that film. But it would not show, and we submit to this court, that fact alone could not and would not show that this defendant or this appellant had ever viewed them. Now, in conclusion, I would like to state that since my opponent has, or my adversary has suggested to this court that this court view the film, he has in effect stated that how does this court know that they are obscene without viewing them? Now that is our very position in this case. We say that with respect to the appellant. The same position holds true. If he has never viewed the films, he would not obviously know that they were obscene, because without viewing them you cannot learn of its obscenity. And that is the point that we have in this case. We say that since the evidence doesn't show that he ever viewed the films, that therefore there's no evidence that he knew or could have known that they were obscene.